The courtroom was quiet. Not the ordinary quiet of a room waiting to begin, but the specific, loaded silence that falls when everyone present understands that something has just shifted, and no one is sure yet which way it went. Judge Judith had been on the bench for 19 years. She had presided over thousands of cases, had heard every variety of lie, deflection, exaggeration, and genuine outrage that civilian court could produce. And she had developed, over those 19 years, a face that gave nothing away. Calm, measured, precise. The kind of judicial expression that made litigants nervous because they could never tell if they were winning or losing. But right now, that face had changed. She was holding a single sheet of paper. She had been holding it for 12 seconds. Long enough that both parties at their respective tables had stopped breathing. Her eyes moved across the document once. Then again, slower the second time. At the defendant's table, a man in a suit that cost more than most people's monthly rent leaned back slightly in his chair, with the practiced ease of someone who had spent a lifetime in rooms where confidence was currency. His name was Harlan Voss. He had $462 million, 2 TED Talks, and the particular kind of smile that people wear when they're certain the outcome has already been decided. The smile was fading. Judge Judith looked up from the paper. She looked at Harlan Voss. She looked at the woman sitting at the plaintiff's table. A woman in a blazer one size too large, her hands folded in front of her with a stillness that looked less like calm and more like something held very carefully together. Then the judge looked back down at the paper. She said nothing. That was the moment. That 12-second silence. That second reading. That look. That was the moment the entire case turned. No one in that courtroom knew it yet, but they were about to find out. Does Harlan Voss look confident to you right now? Or does he look like a man who's just realized something? Drop it in the comments. I'll be reading every single one. And stay with me, because what's on that piece of paper is going to change everything. To understand how a billionaire and a single mother from Caldwell County ended up in a televised courtroom on a Wednesday morning, you have to go back 18 months. Back to the announcement. The Voss Foundation Scholarship Gala was the kind of event that generated its own press release before anyone arrived. 300 guests. A ballroom in downtown Charlotte. Harlan Voss at the podium in a charcoal suit, speaking the language of philanthropy with the fluency of a man who had been coached on it. Giving back, community investment, the next generation of innovators. His foundation awarded 12 scholarships per year to high-achieving students from low-income households. Full tuition. 4 years. The kind of offer that doesn't just open a door, it removes a wall. Destiny Cole had earned one of those scholarships. She was 17 years old, the daughter of Maricela Cole, who worked 2 jobs. A day shift at a medical billing company and 3 evenings a week at a grocery chain, and had raised Destiny alone since her daughter was 4 years old. Destiny had a 4.2 GPA, had been accepted to 4 universities, and had deferred her decision on all of them while waiting for the Voss Foundation's notification, because the Voss scholarship, if awarded, would mean her mother could stop working the evening shift. It would mean Destiny could focus entirely on her studies. It would mean, in the specific and unglamorous language of people who count every dollar, that they would be okay. The letter had arrived on a Tuesday, official Voss Foundation letterhead, signed by the Foundation's executive director. It confirmed Destiny Cole as a Voss Scholar, class of the following fall. It outlined the award, full tuition, 4 years, renewable upon satisfactory academic standing. And at the bottom, in a clause that Maricela had read 3 times and then photographed on her phone before she did anything else, it stated the following. This award is unconditional, upon public confirmation, and is binding upon the Foundation from the date of the scholar's public announcement. Maricela didn't know what binding meant in a legal sense. She looked it up. She read the definition twice. Then she called Destiny into the kitchen and showed her the letter. And Destiny had sat down slowly at the table, the way people sit when their legs have stopped working, because something too large to immediately absorb has just happened to them. They celebrated. Quietly, because that's how Maricela celebrated things. With the particular restraint of someone who has learned that joy held too loosely gets taken back. They had dinner together, just the 2 of them. Destiny called the 4 universities she had been accepted to and declined their offers. She was a Voss Scholar. She had the letter. She had the photograph of the letter. She had been introduced at the public gala 2 weeks later, her name spoken into a microphone by Harlan Voss himself, her photograph on the Foundation's website by the following morning. She thought it was done. It wasn't. The revocation letter arrived 9 weeks later. It came from the same Foundation letterhead, signed by the same executive director, and it explained, in the careful language of institutional regret, that due to a restructuring of Foundation priorities and a reallocation of resources, Destiny Cole's scholarship award had been rescinded. The Foundation apologized for any inconvenience. It wished her well in her future academic endeavors. Any inconvenience. Maricela read the letter standing at her kitchen counter at 6:47 in the morning, still in her work clothes from the evening shift she had just come home from. She read it twice, then she sat down on the kitchen floor. Not dramatically, just because her legs had done the same thing they'd done when Destiny showed her the acceptance letter. Except now they were doing it for the opposite reason. And she sat there for a while. Destiny had no scholarship. She had no other offers. The university she had declined had already filled their incoming classes. The window had closed. Her daughter, who had a 4.2 GPA and had done everything correctly, was starting the fall without a plan. Maricela called the foundation. She was told the decision was final. She called twice more. She was told the same thing in progressively shorter sentences. She wrote a letter. It went unanswered. And then she called a legal aid clinic, where a third-year law student read the original scholarship letter, got to the binding clause, and said, quietly, the way people say things when they want to be careful not to get someone's hopes up too early. Have you contacted anyone else about this yet? She hadn't. She did after that. Harlan Voss arrived at the courthouse with 2 attorneys, a personal assistant, and the energy of a man attending a minor inconvenience. He had agreed to appear on the televised small claims program through his legal team's calculation that resolving the matter publicly, quickly, and with the right performance of reasonable regret would be cleaner than prolonged litigation. His lead attorney had prepared a defense built around the foundation's internal restructuring, the discretionary language in the scholarship program's general terms, and the argument that the specific letter Maricela Cole had received was not legally enforceable, that the binding clause applied to the foundation's public announcement process, not to the individual award. It was a defensible argument. Harlan's attorney had made worse ones prevail. Maricela Cole arrived with a manila folder, a printed email chain, and the blazer she had borrowed from her coworker because she didn't own one that fit properly, and she wanted to look like someone who belonged in a room with marble floors. She looked, to the casual observer, like a woman who was already losing. She was not. Judge Judith entered the courtroom at 9:02 and brought the room to order with the particular efficiency of someone who has 19 years of practice at making 60 seconds feel like authority. She reviewed the case summary. She looked at both parties. Ms. Cole, she said, you're the plaintiff. Tell me what happened. Maricela told her, clearly, without embellishment, without the performance of distress, without editorializing. She had rehearsed this, not with anyone coaching her, but alone, in her car, in the parking lot of the grocery store where she worked her evening shift, running through it until the emotions stopped getting in the way of the facts. She described the letter, the public announcement, the declined university offers, the revocation, the unanswered calls. She spoke for 3 minutes and 40 seconds, and when she finished, the courtroom was quiet. Judge Judith turned to Harlan Voss. Mr. Voss, your response. Harlan Voss did something then that his attorney, reviewing the footage later, would identify as the first mistake. He smiled. Not a warm smile. The other kind. The slight, angled smile of a man who finds the premise of the challenge faintly amusing. He adjusted his cufflink. He said, in a voice calibrated precisely between sympathy and condescension, Your Honor, I want to start by saying I have tremendous respect for Ms. Cole and her daughter. What happened here was an unfortunate administrative situation, and my foundation genuinely regrets any hardship caused. He paused. The pause was practiced. But the reality is that scholarship programs operate with discretion. Circumstances change. Funding priorities shift. And the letter Ms. Cole received, while I understand she interpreted it as a guarantee, does not constitute a binding legal contract under the terms of our foundation's program guidelines. He sat back. He folded his hands. He looked like a man who had said what needed to be said, and was now waiting for agreement. Judge Judith looked at him for a moment. Just a moment. Then she looked at Maricela. Ms. Cole, do you have documentation you'd like to submit? That was when Maricela reached into her bag. She placed 3 things on the table in front of her, in order. The original scholarship letter, the printed email chain, 41 emails between the foundation's executive director and Maricela over a 6-week period, confirming every detail of the award, including its unconditional nature. And a single page she had separated from the rest with a paperclip, which she handed to the bailiff to present to the judge. It was the binding clause, photographed, printed, highlighted in yellow. This award is unconditional upon public confirmation, and is binding upon the foundation from the date of the scholar's public announcement. Harlan Voss's lead attorney leaned forward slightly. He had reviewed the original letter in preparation. He had read the binding clause. He had constructed his argument around the interpretation that binding referred to the foundation's internal process, its obligation to make a public announcement, not to the individual scholar's award. It was a reading that required some work, but it was not unreasonable. What he had not seen, what no one at the defense table had seen, because it had not been produced in the pre-hearing documentation exchange, was the email. The email was from the foundation's own executive director, sent to Maricela Cole 11 days after the binding clause letter, in response to Maricela asking a simple, direct question. Does this mean the scholarship cannot be taken back once Destiny's name is announced publicly? The executive director had replied in 3 sentences. The third sentence read, yes. Once a scholar is publicly confirmed, the award is unconditional and the foundation has no mechanism to rescind it. Harlan Voss's attorney saw this email for the first time when the bailiff placed Maricella's documents before the judge. He recognized, immediately and with the particular clarity of a professional who understands exactly what he is looking at, that this was a problem. He leaned over and said something quietly to Harlan Voss. Harlan Voss's expression, which had been arranged in the posture of patient, reasonable authority, shifted by approximately 3 millimeters. It was barely noticeable. It was the most honest thing he had done all morning. If you've ever been publicly promised something and then had the rug pulled out, like this video if you believe a public promise should never be broken. Because what Judge Judith is about to read is going to settle this question once and for all. Judge Judith read the email. She read it the way she had read the binding clause document a moment earlier. Once, then again, slower. The courtroom had gone to that particular quality of silence that feels less like absence of sound and more like presence of pressure. She set the papers down. She looked at Harlan Voss. Mr. Voss, she said. Her voice had not changed. It was still calm, still even, still carrying the precise temperature of 19 years on the bench. Your foundation's executive director sent a written communication to the plaintiff, stating, and I'm quoting directly, "The award is unconditional, and the foundation has no mechanism to rescind it." Is that an accurate characterization of your foundation's operational policy? Harlan Voss looked at his attorney. His attorney was already constructing something. You could see it. The slight forward lean, the intake of breath that precedes a pivot. He said, "Your Honor, internal communications from staff members don't necessarily reflect." "I didn't ask about internal communications," Judge Judith said. She did not raise her voice. She did not need to. "I asked Mr. Voss whether that statement accurately reflects his foundation's policy." Harlan Voss said, "I would need to defer to counsel on the specific." "Mr. Voss." She said his name the way a judge says a name, when they want the name itself to be a message. "You are the founder of this foundation. You are its public face. You spoke this young woman's name into a microphone at a public event and announced her as a Voss scholar. I'm asking you a straightforward question about your foundation's operational policy." The courtroom was absolutely still. Harlan Voss was a man who had built a $400 million company on his ability to read a room and position himself correctly within it. He had given keynote addresses to rooms of 1,000 people. He had navigated regulatory hearings, investor calls, board disputes, and a congressional testimony. He was not, by any measure, a man who lost his composure easily. But composure and certainty are different things, and the certainty had left the room. "Your Honor," he said slowly, "the foundation's intention was always to support deserving students. If there was a miscommunication..." "There was no miscommunication," Judge Judith said. "There was a written letter with a binding clause. There was a subsequent email explicitly confirming that the award could not be rescinded. There was a public announcement. And then there was a revocation letter." She paused. "That is not a miscommunication. That is a sequence of events." Harlan Voss said nothing. It was the first time since entering the courtroom that he had nothing to say. His attorney tried again. "Your Honor, the enforceability of a scholarship award under private foundation law." "Counselor." The judge looked at him with the patience of someone who has heard every variety of legal deflection and has decided not to waste time on this particular one. "Your client's foundation issued a letter with explicit binding language. Your client's foundation's own executive director confirmed in writing that the award was unconditional and non-rescindable. Your client then revoked the award after a public announcement was made, causing the plaintiff's daughter to decline multiple university offers based on reliance on that award." She set her hands flat on the bench in front of her. "Tell me which part of that sequence you believe does not constitute an enforceable obligation." The attorney said nothing. There was, for the first time, nothing useful to say. At the plaintiff's table, Maricela Cole sat with her hands still folded in front of her. She had not looked triumphant. She had not looked relieved. She looked like a woman who had been carrying something very heavy for a very long time and had not yet received permission to put it down. She thought it was almost over. She was right, but not before one more thing happened. Harlan Voss leaned forward. And this was the moment that his attorney would later describe, privately and with considerable frustration, as the second mistake. He said, in a voice that had lost its careful calibration and found something less managed underneath it, "Your Honor, with respect, my foundation has invested millions of dollars in students across this state. We have changed hundreds of lives. This is one case involving one student, and I think it's important to keep perspective on." "Mr. Voss." Judge Judith's voice cut through the sentence cleanly and completely. "I want to make sure I understand what you're saying. You're asking me to consider the volume of your philanthropy as a relevant factor in a case where you revoked a confirmed, binding scholarship award from a 17-year-old girl who had declined all other university offers based on your foundation's written promise? Harlan Voss heard what he had said, in this room, with this framing, reflected back at him. He heard it the way you hear your own voice in a recording, and recognized something you'd rather not recognize. He said, "That's not what I understand what you meant," the judge said. And in those 4 words was everything. The 19 years, the thousands of cases, the complete and unhurried authority of a woman who had heard every version of power explaining itself and had stopped being impressed by any of them. The volume of good a person or institution does in the world does not create a credit balance that they can draw on when they've harmed someone. That is not how accountability works. She picked up her pen. She looked at the documents one final time. The binding clause, the email, the public announcement record that Maricella's attorney had included in the submission, a screenshot of Destiny Cole's name and photograph on the Voss Foundation's own website, under the heading, Voss Scholars Confirmed. She looked at Maricela Cole. "Ms. Cole," she said, "how much is full tuition at the university your daughter was planning to attend?" Maricela gave the number, 4 years of tuition, housing, and academic fees. Judge Judith wrote it down. She looked at Harlan Voss. "Before I tell you what she ruled, if stories like this matter to you, subscribe to this channel. New stories every week. Hit the bell so you never miss one. Because justice, when it finally arrives, deserves an audience." "Mr. Voss," Judge Judith said, "your foundation made a promise. It made that promise in writing, with explicit binding language. It confirmed that promise in a subsequent written communication. It announced that promise publicly at a formal event, before an audience of 300 people, with your name and your voice attached to it. The plaintiff's daughter relied on that promise in the most consequential way a young person can. She declined every other opportunity available to her, because your foundation told her, in writing, that she had already secured the most important one." She paused. "Not for effect, for precision. The law in this matter is not ambiguous. A promise that induces reasonable reliance and causes demonstrable harm upon its breach is enforceable. Your foundation's own language, the binding clause, the executive director's email, removes any argument about intent or interpretation. This was not a guideline. This was not an aspiration. This was a commitment." She signed the judgment form. "I am ruling in favor of the plaintiff. The Voss Foundation is ordered to fulfill the scholarship award in full, 4 years of tuition and associated academic fees, to Destiny Cole, beginning with the next academic enrollment period. Additionally, given the documented harm caused by the revocation, specifically, the plaintiff's daughter losing her other admission offers due to reliance on this award, the foundation is ordered to provide a supplemental transitional award to cover 1 year of additional educational costs incurred during the gap period." She set the pen down. "Mr. Voss, I want to say one more thing, and I want you to hear it clearly." She looked at him with an expression that contained no malice and no theater, just the straightforward regard of someone with something important to say. "You built a foundation and gave it a name and put your face on it. That is not a criticism. That kind of public commitment to education matters. But a foundation is not a marketing exercise. It is a promise. And when you put your name on a promise, you do not get to revoke it, because the budget shifted, or the priorities changed, or the cost became inconvenient. Especially when the cost is being paid by a 17-year-old girl, who did everything right." She looked at Maricela Cole. "Ms. Cole, your daughter is a Voss scholar. She was always a Voss scholar. The paperwork just needed to catch up with the truth." She closed the file. The room was silent for a moment. The last kind of silence, the one that falls after something has been resolved rather than suspended. And in that silence, Maricela Cole unfolded her hands for the first time since she had sat down. She placed them flat on the table in front of her. She looked at the documents, the letter, the email chain, the highlighted clause, and she breathed. Harlan Voss stood. He buttoned his jacket. He said nothing. He walked toward the exit with the 2 attorneys and the personal assistant. And if the posture was still assembled correctly, the expression was not. He looked, for the first time since entering the building, like a man who had been in a room and lost something in it. He had lost something in it, just not something he could put a dollar amount on. Destiny Cole enrolled the following spring semester. She studied computer science. She made the dean's list in her first year, and her second. She graduated in 4 years with distinction, and a job offer from a technology company in Raleigh that had nothing to do with the Voss Foundation, and everything to do with a young woman who had refused to stop moving forward, even when the ground had been pulled out from under her. Maricela sold the borrowed blazer back to her coworker, and bought one of her own. She kept working the day shift. She stopped working evenings. The binding clause letter, the one Maricela had photographed on her phone the night the acceptance arrived, the one she had carried in a manila folder through a courthouse with marble floors and placed before a judge who knew exactly what she was looking at. That letter went into a frame above Destiny's desk in her dormitory, not as a trophy, as a reminder of what a promise looks like when it's written down, and what it looks like when someone decides to keep it. Because that's what this story is, at its core. Not a story about a courtroom, or a billionaire, or a judge who had seen everything, and was still capable of being moved by the specific weight of a documented truth. It's a story about what we owe each other when we make a promise out loud, in public, with someone's future attached to it. A promise is not a marketing strategy. It is not a gesture. It is not something you get to take back, because the cost became clearer than you expected. Maricela Cole knew that. She'd known it her whole life, had built her whole life around it, in fact. 2 jobs, 1 daughter, every promise kept. She just needed 1 room, 1 judge, 1 piece of paper, and 12 seconds of silence to make sure the rest of the world knew it too. This story is a fictional dramatization, inspired by televised courtroom themes. All characters, events, and institutions depicted are entirely fictional, and are not intended to represent any real persons, living or deceased, or any actual legal cases or proceedings.